Have you ever been pulled over at night, heart pounding, watching the officer walk up in your side mirror, and notice just barely a quick tap on your tail light? Most drivers miss it, but that small, almost invisible move can quietly shape everything that happens next, from how long the stop lasts to what ends up written in a police report, and even what a judge believes months later. Tonight, we're breaking down what that taillight touch can mean, why it matters more than you think, and the precise lawful steps you can take to protect yourself without being rude, aggressive, or confrontational. This is not about arguing. It's not about escalating. It's about understanding the legal framework that governs traffic stops and using it correctly. By the end of this video, you'll know exactly why officers sometimes touch your vehicle, how documentation can protect you, the right way to decline investigative questions, how to refuse a vehicle search properly, and the Supreme Court decisions that define your rights. If you drive, this matters. Let's start with the moment almost no one notices. You're driving home. Maybe it's late. Maybe you changed lanes a little too quickly. Or maybe you were slightly over the speed limit. Suddenly, flashing lights appear behind you. You pull over safely. You turn off the engine. You turn on your interior light. You place your hands on the steering wheel. So far, everything is textbook. The officer exits their patrol vehicle and walks toward you, and as they approach, they lightly tap your tail light. It's subtle, it's quick, it might even seem meaningless, but it isn't meaningless. Traditionally, one commonly cited reason for that touch is officer safety, leaving fingerprints on the vehicle in case the driver flees. Whether that's common practice everywhere or not, the more important legal reality is this: that moment draws attention to the condition of your vehicle. If a taillight is cracked, damaged, or later claimed to be defective, that detail can become part of the narrative of the stop. Now let's be clear, officers are allowed to enforce traffic laws. If a vehicle defect exists, they can cite it. That's lawful. The issue arises when there's a dispute about when or whether damage existed. And here's where most drivers unintentionally put themselves at a disadvantage. They ignore the contact. They sit silently. They wait for the officer to reach the window. They hand over their documents. They begin answering questions. But imagine this scenario months later in court. The report states the vehicle was stopped due to a defective tail light. You insist it was working properly before the stop. The officer's written report says otherwise. Without documentation, whose account is likely to carry more weight? Now let's talk about what you can do, calmly, legally, and professionally. The moment you notice physical contact with your vehicle, you activate your phone's audio or video recording function. You clearly and calmly state, "The officer just made contact with my tail light at... My tail light was fully functional prior to this stop." That's it. No sarcasm, no hostility, no accusation. You are simply creating a time-stamped record. If you have a passenger, they can discreetly record the taillight from inside the vehicle. Again, not interfering, not exiting the car, not escalating, just documenting. This is important because courts have consistently recognized the right to record police activity in public as long as you are not interfering with their duties. And while Pennsylvania v. Mims established that officers may order drivers out of their vehicles during lawful traffic stops, it does not eliminate your right to document the encounter. Documentation changes dynamics. When there is a clear time-stamped record created in real time, it becomes significantly more difficult for facts to shift later. Now let's move to phase 2 of the stop, the conversation. After collecting your license, registration, and proof of insurance, the officer will often begin asking questions. Where are you coming from? Where are you headed? Do you know why I pulled you over? How long were you there? Have you had anything to drink? These questions may sound conversational. They are not random. Every answer you provide can potentially extend the stop. This is where many drivers unintentionally open the door to deeper investigation. You say you're coming from a friend's house. Which friend? How long were you there? Did you have anything to drink? Why were you in that area so late? A simple answer becomes a chain of additional questions. And here's the key legal concept. Traffic stops are supposed to last only as long as necessary to address the original reason for the stop. That principle was reinforced in Rodriguez v. United States, where the Supreme Court ruled that officers may not prolong a traffic stop beyond the time reasonably required to handle the traffic violation, absent independent reasonable suspicion. So how do you protect yourself? You remain polite. You provide required documents. But when investigative questions begin, you calmly say, I'm not answering questions. Am I being detained? Or am I free to leave? Say it clearly, say it calmly, then stop talking. Silence feels uncomfortable. That's why it's powerful. The right to remain silent is not just a TV slogan, it comes from Miranda versus Arizona. While Miranda warnings are typically associated with custodial interrogations, the broader Fifth Amendment protection against self-incrimination still applies. And in Berkmer versus McCarty, the Supreme Court clarified that individuals subjected to traffic stops are not stripped of their Fifth Amendment protections simply because the stop is temporary. You are required to identify yourself and provide vehicle documentation. You are not required to answer questions about your day. Now let's address what happens next in many stops. After a few unanswered questions, the officer may return to their patrol vehicle, run your information, and then come back. Sometimes you'll receive a citation, sometimes a warning, and sometimes, this is the pivotal moment, you'll hear, do you mind if I take a look inside your vehicle? Can I search your car? Mind if I check your trunk real quick? This moment decides everything. Here's the legal reality. If officers already had probable cause to search your vehicle, they would not need your consent. When they ask, they are seeking voluntary permission. And once consent is given, challenging the search later becomes extremely difficult. The correct response is simple. I do not consent to any searches. That sentence alone can preserve your Fourth Amendment protections. The Supreme Court addressed consent searches in Schneckloth versus Bustamante, holding that consent must be freely and voluntarily given to be valid. In United States versus Drayton, the court confirmed that officers may request consent without advising individuals of their right to refuse, but individuals absolutely retain that right. And in Florida versus Bostick, the court emphasized that refusing consent cannot be used by itself as evidence of guilt. So why do so many people say yes? Because they think saying no makes them look guilty. But legally, refusing consent cannot create reasonable suspicion by itself. Now let's discuss the psychological pressure phase. After you say, I do not consent to any searches, you may hear, if you've got nothing to hide, why not let me look? It'll only take a second. You're making this harder than it needs to be. This is not about legality anymore. It's about psychology. The correct response remains, Officer, I'm exercising my constitutional rights. I do not consent. No debate, no justification, no argument. Repeat your position calmly. If the officer says they're calling a K-9 unit, understand this. Under Rodriguez versus United States, the stop cannot be extended beyond the time necessary to handle the traffic violation without independent reasonable suspicion. If reasonable suspicion already exists, a K-9 may be deployed. If it does not, the stop cannot be prolonged solely to wait for one. Your refusal does not create suspicion. Now let's walk through a complete scenario. You're driving home at 10:15 p.m., you see flashing lights. You pull over safely, engine off, interior light on, hands visible. The officer approaches and taps your taillight. You activate your phone and calmly state, the officer just made contact with my taillight at 10:15 p.m. My taillight was fully functional prior to this stop. The officer reaches your window, license and registration. You provide them. Do you know why I pulled you over? I'm not answering questions. Am I being detained or am I free to leave? You're being detained for speeding. I understand. I'm not answering questions without my attorney present. Silence. The officer asks where you're coming from. Silence. The officer returns to the patrol vehicle, comes back with a warning. Do you mind if I search your car? I do not consent to any searches. Why not? I'm exercising my constitutional rights. I do not consent. A pause. You're free to go. No search, no escalation, no additional charges. Now contrast that with the common version. No documentation of the taillight. Friendly conversation turns into extended questioning. Nervous laughter. I don't have anything to hide. Consent granted. An old item in the trunk becomes a legal problem. What began as a simple speeding stop becomes a complicated court case. Let's tie everything together with foundational law. Terry v. Ohio established that officers need reasonable suspicion to detain someone. Pennsylvania v. Mims allows officers to order drivers out of vehicles during lawful stops. Schneckloth v. Bustamante governs voluntary consent to search. Miranda v. Arizona protects your right against self-incrimination. Rodriguez v. United States limits how long a stop can be extended. These cases don't eliminate police authority. They define boundaries. Officers are trained to investigate. They are trained to ask. They are trained to seek consent. That's their job. But you are allowed to understand the legal structure that governs those interactions. And when you calmly, professionally invoke your rights, you shift the encounter from reactive to strategic. Let's recap the four critical protections. First, document any physical contact with your vehicle in real time. Second, decline investigative questions politely and clearly. Third, refuse consent to searches using precise language. Fourth, remain calm and silent after invoking your rights. No anger, no hostility, no resistance, just clarity. Because here's the truth. The difference between a simple warning and a complicated legal battle often isn't what you did before the stop. It's what you said during it. If this breakdown helped you understand traffic stops at a deeper level, make sure you're subscribed, because in the next video, we're analyzing one of the most commonly cited justifications for vehicle searches and what the courts actually say about it. Drop a comment below and tell me which part of this surprised you the most. And remember, stay calm, stay professional, and always know the rules before you're the one pulled over.